Leave granted staff para. The appellant and respondent number 1 were married according to Hindu rites on 7/5/2004 and from the wedlock were born a son within bracket respondent number 2 bracket out and a daughter within bracket respondent number 3 bracket out who are now about 11 years and 8 years respectively star. It appears that the marriage ran into problem at some stage and all endeavors for reconciliation failed star. The appellant and respondent number 1 both are qualified doctors who were deployed with the CRPF throughout which position exists even today stop para. The appellant and respondent number 1 ultimately agreed for a decree of divorce by mutual consent and filed a petition under section 13B of the Hindu Marriage Act 1955 star. The first motion was filed in June 2016 and after the expiry of the statutory period of 6 months, the second motion was passed and a decree of divorce was granted on 9/12/2016 stop para. The two relevant terms of the decree of divorce for the purposes of this present appeal are extracted as under para code. That petitioner numbers 1 and 2 are at liberty to marry with any other person of their choice stop para. In future, petitioner number 1 has no any right of husband over petitioner number 2, so also petitioner number 2 has lost right as wife over petitioner number 1 today stop para. That petitioner numbers 1 and 2 both are agreed to custody of both the children residing with petitioner number 1 stop. Petitioner number 1 will provide education, medicines, and marriage of Arok Kumar, son of Amit Kumar, stop. Petitioner number 2 will provide education, medicines, and marriage of Riya Kumar, daughter of Amit Kumar, stop. D code para. A perusal of the aforesaid shows that para 5 was a natural corollary to the decree of divorce, that is, that either parties could remarry star. Clause 6 provides for an agreement inter se the appellant and respondent number 1 qua the issue of custody of both the children, which was agreed to be with the appellant staff. However, possibly in view of their similar financial strength, it was agreed that the appellant would provide for education, medicines and marriage of the son, while respondent number 1 would do the likewise for the daughter stop para. The parties at the relevant time were posted in Nanded and thus, initially the arrangement for custody worked out fine stop. The issue, however, arose once the appellant was transferred out of Nanded stop. The appellant was transferred to Jammu, which apparently necessitated him to make arrangements for admission of respondent numbers 2 and 3 to a boarding school in Pune, while he assessed the possibility of bringing the children to live with him in Jammu stop. The undisputed fact is that at no point of time did respondent number 1 make any financial contributions towards her obligations, in terms of the decree of divorce by mutual consent stop. The appellant sent a legal notice dated 28/3/2017 to respondent number 1 pointing out this fact and demanding the payment of unpaid amounts, apart from the amount required for securing admission and meeting the living expenses of the daughter in the boarding school at Pune stop. It is this demand which seems to have triggered of the present dispute stop para. Respondent number 1 sent a reply to the aforesaid notice through her counsel on 15/4/2017.